Hello, everyone. This is Arthur Hardy Doubleday, attorney at Doubleday Law, located in Cambridge's Central Square, 45 Prospect Street. Today, I want to talk to you about heat, Massachusetts heat law, and how it applies to tenants and landlords. I am a huge fan of fall for a number of reasons. I'm pretty sure Halloween's my favorite holiday. Football, big football fan, and obviously the leaves are changing. One of the benefits of living in New England is we have this change in season. We go from summer to fall, and while that's wonderful, sometimes we wake up and it's freezing, and sometimes the very next day it's like, very warm outside. So the issue that you have to ask yourself as a tenant is, what is the landlord's obligation to heat your apartment? Surprisingly enough, September 16th through June 14th, the interior of the apartment has to be 68 degrees from 7 a.m. to 11 p.m. in Massachusetts. Okay? Here in this picture, I think it's hilarious. Halloween, and it's snowing out. And these kids look clearly lost. Their parents are awfully excited, but they're just like, this is not supposed to be happening. So, if by chance it's snowing on Halloween and you don't have any heat on, potentially your landlord is responsible. Okay? Who pays for heat? If it's in writing, if it's in your lease, all right, tenant pays for heat, and the landlord, if it's a multifamily building, submeters the heat, right? So your heating bill is only for your apartment and no common areas. Then you pay for your heat. If there's no writing, or if your landlord does not submeter your heat, let's say the landlord lives below you, and you're paying for heat for the entire building, and it might say it in your lease, that's illegal. Your landlord has to pay for the heat because it's your landlord's heat and your heat, or the downstairs tenant's heat and your heat. Landlord has to pay. If there's no writing, landlord has to pay, and that's actually all utilities. If there's a written agreement for utilities that the tenant pays, and it must be submetered. If there's no written agreement, or if it's not submetered, landlord pays. What you need to do in a situation where your heat goes off, or the heat's in your name and it shouldn't be, you need to report it to your landlord. I would call and report it. And then you also need to put it in writing. You need both the verbal and the written. Verbal, because you want it to be fixed right away, right? So you need to report it to your landlord. Your landlord's technically not liable until your landlord's informed. In writing, because you need some sort of memorialization that you did make that phone call, you did make contact, that you did request the heat to be turned on, or the utilities to be switched into the landlord's name. Okay? Then you want to report it to the Board of Health. So my office is located in the city of Cambridge, and this is City Hall. You want to call up City Hall, you want to figure out whoever the health agent is, and you want to report it to them. My heat's off. I need you to come and inspect my unit and order my landlord to turn the heat back on. And this could be for any utilities, your electricity or whatever. If there's no written agreement, your landlord's responsible. You want to report it both verbally to the Board of Health and in writing. So you want to call it in, and then you also want to write a letter. That could be an email, that could be a fax, it could be anything, as long as it's in writing. All right? You also want to document the condition. So here, there's a gentleman pointing at the thermometer. What you can do is take a picture of that so it's clear, so you can see what temperature is at. You want to make sure it's time-stamped and date-stamped, so what you might want to do is like hold up the Boston Globe or the Boston Herald next to the thermometer to document the time, or sometimes cameras document the time automatically, and they'll have like a little timestamp below. That's what you want to do to document, okay, on November 15th, it was 12 noon, and my heat was not on, or the temperature in my apartment was 40 degrees. Unacceptable. The goal here is to get the heat turned back on. Okay? The goal is that simple. Or get your electricity turned back on if your electricity's been turned off. It's that simple. However, there are a number of different ways of getting there, and the last measure should be going to court. You can go to court and you can file something called a temporary restraining order, which is a court order from the judge saying, landlord, turn the heat back on. Additionally, you can also assert legal claims, one of which is breach of warranty of habitability, which as damages is a percentage markdown of what you should be paying in rent based on what the market rate rent is versus the condition you're presently living in. All right. Another way of calculating it is a breach of quiet enjoyment, which the damages are 2 to 3 times 1 month's rent, plus attorney's fees and cost. All right. Ultimately, our original goal is to get the heat turned back on. You call up the landlord. You put it in writing to the landlord. You report it to the Board of Health, both by calling and putting it in writing. And then the Board of Health hopefully comes and inspects and issues an order. But you also can bring the landlord to court and get your damages. Things to remember: September 16th through June 14th, 68 degrees in your apartment from 7 a.m. to 11 p.m. If you have a written agreement with your landlord and there's no commingling of the utilities, you pay. If it provides in that written agreement that you pay. If you don't have a written agreement or the utilities are being commingled, meaning you're sharing your heat with downstairs or upstairs people, landlord pays. You want to report it both verbally and in writing to your landlord. You want to report it both verbally and in writing to the Board of Health. You can go to court. This is where we come in. We go to court. We ask the judge for a temporary restraining order to issue forthwith, meaning immediately. We assert the claim of breach of warranty of habitability. And we also assert the claim of breach of quiet enjoyment, which provides for 2 to 3 times 1 month's rent, plus attorney's fees and cost. Know your rights. Get in contact with me if you have any questions. I'm at 45 Prospect Street, Cambridge, Mass. Come in, we're going to have a cup of coffee and talk it out and figure out what the solution is to your problem. Hope you have a good day and you're staying warm this winter.